Hello, hello, everyone. How's everybody doing? I know that the weather is beginning to settle a little bit. Things are beginning to calm down. For those of you who didn't see last week's Facebook Live, we talked about what to do when your visitation schedule is being disrupted by weather. So feel free to scroll down, find that, and give that a review. I think that was, they're usually about 10 minutes long. So check that out if you missed that from last week in case you had some problems with your visitation schedule. Okay, so today's topic is what to do when your court appearance went badly, when things didn't go your way. So there's really three pieces to this, all right, what you need to do. But first, I want to talk about what really the makeup is of a court appearance. For those of you who have already been court appearances, you know that a lot can happen fast. A lot can happen fast. So the number one thing I tell people to do is to make sure that your lawyer is prepared, give them talking points, have them ready. Now, that is not to say that if court doesn't go your way, that it was your fault. So let's talk about what the court is looking for. What we find is that what defines what didn't go well in court is when your co-parent gets more time with the kids than they ever even had when you were married. Suddenly they're asking for all kinds of time and they're getting it. The court is giving it to them. Or if you are the non-custodial parent, that your time didn't increase as much as you wanted it to, or you just didn't get all the terms you wanted. Right. So with each court appearance, even if you're going into what's going to become a trial, which we want to try to avoid, remember, they're still going to use each court appearance. Decisions will be made. Temporary decisions will be made and a stamp will be put on it by the judge. And that's something that they want to see. Will this work? So the first thing to do is to think about, okay, this is what the court wants to see. Will this work? Keep in mind that the court wants to try to get as much time with each parent as possible. It used to be that the standard was about an 80-20, 80% to the primary parent, 20% to the non-custodial parent. A lot of the court system is now trying for 50-50. They believe that that's the best interest of the child. So what they're thinking is, and on this is, more time, equal time with each parent is probably what's best for the kids. And that's what they're starting to believe. So what we want to do is we want to find a way to sort of steer them toward what the best custody arrangement is for your family. So they want to slowly increase time for the parents to try to get to 50-50. They like it. The burden suddenly becomes on the non-custodial parent to prove why they should get more time. But now they're even moving more towards the burden being on the primary custodial parent to say, well, why shouldn't it be 50-50, right? Whereas we know that 80-20 or 70-30, and again, those are percentages from primary caregiver to non-custodial parent. What we know is that statistically speaking, studies show that that kind of rhythm, that kind of what's the word I'm looking for? Consistency and routine is really good for kids when there is a high conflict relationship between the parents. When you have a disordered parent, which most of my clients, almost all of my clients, we are dealing with a cluster B personality disordered parent. They're either a narcissist or they're bipolar. There are other cluster B personality disorders, but those are the main ones that drive divorced, broken up, split up parents to court. Here are the three things that I want you to think about when you walk away out of a court appearance and it did not go the way that you wanted to. There's three ways that you want to adjust going forward while accepting that the court is sometimes just looking for things. The first piece is always going to be strategy. Okay, so what you need to determine with your lawyer is, what is our strategy here? And how does your strategy shift after each court appearance? So the biggest thing that moms complain about, that parents complain about that didn't work well is that their co-parent got way more time than they had before, way more time than they even have to spend with the kids, and yet they want it, and the court is giving them more. One of the things that you can focus on there is that if you have a disordered co-parent, this is giving them rope. All right. They're going to show the court in court. Of course, they're charming, they're wonderful, they've got great impression management. Once they're out of court and behind closed doors, you know what they're really like. The court doesn't. So your strategy here is to start gathering evidence to show that narcissism, to show the high conflict behavior, quite frankly. What a lot of moms, what a lot of parents tend to do then is as soon as their ex wins a little bit more or a lot more parenting time, they want to start controlling things. They want to go in and they want to say, well, don't forget to do this and this, that, and the other thing. Keep them informed and don't hold back information from them. But by the same token, keep in mind that you're going to look controlling if you're telling them, they didn't go to bed at this time or this, if they don't have the same routines at their house and you're trying to make them have the same routines at their house. This is part of giving them rope. A good parent will know you have to have a bedtime routine. You have to make sure their teeth are brushed in the morning, at night. You have to have them in clean clothes. You have to change their diapers. A good parent will know these things. You shouldn't be telling them these things. I know you're trying to protect your kids, and obviously you're warranted to say, look, these are the things that we're used to. These are the things we're doing. Now that you have them on Saturdays, they have Aikido. Now that you have them here. So what you want to make sure you're not doing is micromanaging that. Okay. The second thing is your mindset. This is huge. And a lot of my clients focus a lot on strategy and not so much on mindset. But the thing of it is that mindset makes a huge difference in how you appear in court. It's very striking that some of the clients that we get here have lost primary custody when they had it simply because of the way they appeared in court. So your mindset, what you're going in with, how you're appearing in court is a huge thing. It's really going to make a huge difference. So get feedback from your lawyer. Lawyers aren't going to give you straight up feedback as much as you like unless you ask. So when it comes to how you're appearing in court, ask about that. Okay? So you want to find a way to release anxiety and not come in looking like someone who's recovering from the psychological abuse that you've had. All right? Now, what then is the last thing that's going to help your next court appearance? It's evidence. So you should be documenting just about everything. You know that. But now that you've lost a court appearance, now that there's something that you lost at the last court appearance, whether it was one thing or a number of things, what you now need to do is you need to keep even tighter documentation on those things. Because now that the court has said, well, your co-parent should have this, this, and this, that can be part of your strategy now. Take those things, that X, Y, and Z that the court said, we want to give your co-parent this, even though they don't have it now. And they're taking that away from you and they're giving it to them. Take those things and start watching those closely. Maybe your co-parent will succeed and it'll be great. But more likely, if you're in court against a disordered parent, you're going to need to have some sort of evidence to show this is what we're dealing with. Because your end goal is to get the custody arrangement that you think is best for your kids. And if along the way, some of the things that you're noting that your co-parent learns and says, these are things I got to keep on my toes about because she's watching me, right? That's not a bad thing because they're becoming better parents. But what we know is that they're going to show their true selves. They're going to show who they are. And this gives you an opportunity to gather that evidence. So, I'm not one to say that there's always a silver lining, right? But what I will say is when a court appearance doesn't go the way that you want and you've lost some things or they've gained some things that are not great for the kids, you want to have the strategy, you want to have the evidence, and you want to have the mindset. Those are the three things that I've discussed here, okay? So those are the things that you want to focus on. And with your lawyer, think about what your strategy should be for the next appearance. Take a look at what didn't work during the appearance where you lost some things that you don't want to lose, where things didn't go your way. Because a lot of times the breakdown is it's the partnership between your lawyer and you. A lot of people feel like, okay, you know what? This is my lawyer. They're going to go ahead and they're going to go in and do this thing. But that's not the reality of it. You have to build your case. You have to partner with your lawyer and help strategize. Okay. So partner more strongly with your lawyer. For those of you who are already my clients, I'm just going to remind you, mindset is one of the biggest things out of this. We can't leave it out. We can't just focus on strategy and evidence. And for any of you who need help with your evidence and organizing it, just find me at custodycorner.com or ping me here and I can help you. Now I want to see if there are any questions here. Oh man. So what I'm seeing here, I hear this too much. My daughter wore the same clothes for 4 days and 3 nights at his house. Yeah. This is the kind of thing that's kind of unbelievable. So you got to document that. And some people might say, well, how do I document that? One method that you can use is to take a picture of what they're wearing when they leave. Because if you're saying that your daughter was wearing the same clothes and they were filthy on the way back, then you want to get some video or a picture as soon as they are dropped back off to you. So as soon as she's dropped off to you, if you take any sort of evidence on your phone, that's going to be time and date stamped. You should still extract it, download it from your phone, or upload it into whatever you're using to document these things, and then make comments on it. Okay. Remember, the big thing about evidence is you need to show a pattern of it. Now, sometimes things are egregious enough that even if it's one time, you still talk about it, you still bring it in, you still show it as evidence. Something like this feels to me like something that should be brought to the attention of the court. In this case, you would start with the GAL, the guardian ad litem. In your jurisdiction, that might be called the minors counsel, the child lawyer, the friend of the court, whoever's representing your child. Okay. You should bring that to their attention. It should also be brought up in the forensics evaluation, otherwise known as the custody evaluation. That's something that you will want to lump in. And when we're talking about evidence, just to give you a little extra tip, what you want to do, if this is the only time that you can capture evidence of this, because it does no good to say that he does it all the time. You have to have evidence. If this is the only time that you capture this evidence of it, then what you can do, and this is sort of a side angle, is you can lump it in with sort of a general list of neglect. Now, what you want to be careful of, that is a mistake that a lot of parents make, is they have this long list of things of neglect. Remember, when you're presenting to court, don't present things that don't have evidence. So if you can't show a pattern of evidence, a pattern of evidence that shows a pattern of behavior, all right, then you can kind of tuck in where you only have one piece of evidence on something under a larger category. It won't be as effective, but if you have 3 egregious things that happened that aren't showing patterns of behavior in and of themselves, but altogether they show neglect or abuse or non-collaboration or alcoholism or fill in the blank, then that can still be useful. So you're going to be artful about it and partner with your lawyer about that. So yes, if it's happened more than once, you have to ask yourself, well, how many of these do I have evidence for, right? So you want to keep the evidence, you want to keep a pattern of it. And there's 2 ways to approach how to gather that evidence too. Because think about this. You can go back to your co-parent, you can say, look, please have our daughter wearing clean clothing. You know, this is a no-brainer. You wouldn't say it like that, but you would basically email and say, hey, I noticed, you know, she came back and her clothes were dirty. It seems like she was wearing the same thing the entire 4 days she was with you. Can we not do that, right? So you want to make it sound collaborative and non-insulting. That's important because you don't want to be creating evidence against yourself because, man, they use it and it looks bad and it hurts your case. But what you can do is you can do that, sending him and asking him. He'll deny it. He'll do whatever he's going to do. The other possibility is that you don't mention it at all. If you don't think he's going to change and he's just going to rail against you, and excuse me if this is a wife and not a husband, I'm just using he here, then what you need to do is just keep gathering evidence. So you have to choose whether or not you feel like it's going to be useful to say, hey, can you stop doing this in a very collaborative, professional way? Or if you want to just say, he's not, there's nothing I can send to this person, but he doesn't send me something back that's vitriolic. So I may as well just go ahead and document this. And like I said, send it to your GAL, guardian ad litem, and keep it for the evaluator as well. Okay. So I hope that that's helpful for you. I don't see any other questions here. If more questions come in, everyone just go ahead and pop them in the chat below, tag me, and I'll get back to you with some answers on what's going on. Otherwise, remember, if the court appearance didn't go your way, court cases are long. Even, listen, my clients, they work with my blueprint and their cases are amazing after that. But no matter what, you cannot win every single court appearance. All right. So you have to look at those losses and see, okay, what does this tell us? How does this tell us to change our strategy, to pivot? So strategy, how do I need to change my mindset? And what evidence do I now need to gather on these things to show that the court made the wrong decision? All right. Okay, great. I will see you guys next week with a new topic yet to be determined. Have a great day. You've got this. Keep your head up and keep working on your strategy, mindset, and evidence. Bye, y'all.